District Court in the state of Michigan is now in session with the Honorable Donald Coleman presiding. While court is in session, there will be no talking, sleeping, chewing of gum, or reading any material, and also no driving. Thank you.
Good morning to all. This is case number 22-185-078. This is Metro Durable Medical Supply versus Geico Indemnity Company. The matter is before the court pursuant to the court's pretrial scheduling order. Today is an date time set for a pretrial review of this matter. Your appearance for Metro, please.
Good morning, Your Honor. Doug Haraskevich, P81458, on behalf of the plaintiffs Metro and First.
Thank you, counsel. Good morning to you, sir. For Geico Indemnity Company, please, your appearance at this time, please.
Good morning, Your Honor. Michael Fox, P75553, on behalf of defendant Geico.
Thank you, Mr. Fox, and good morning to you as well, sir. I noticed that the discovery cutoff was the 28th of November, and I had a hearing at that time. And then looked like I scheduled it for a subsequent date. Somebody give me a status update on where you are with things at this time.
Your Honor, I could speak first. This is for defendant. We have received discovery responses from plaintiff as well as a demand. I don't know if plaintiff's counsel needs anything additional from me. I think that if Your Honor would consider it, this is a matter that might be better resolved or more easily resolved with the use of case evaluation, if Your Honor would order it and if plaintiff has no objection to it.
Yes, Your Honor. I have no objection to moving this case to case evaluation. This case recently was transferred from a colleague who left the firm to another colleague, Jessica Canarn, and I'm covering for her, and she indicated that she would like to request the claim file on this matter, and I think that'd be appropriate if we're moving forward to case evaluation.
I can produce that easily, yes.
All right, very well. I will set the matter up for case evaluation, and I'll set a control date to have you all back here just in case we need to do anything further. So I'm going to go ahead now, and you'll get an order from me. I'm thinking as it relates to evaluation to have it mediated. Is that appropriate, or did you want to go through some other mechanism?
I would rather do case evaluation given the cost of the case. Mediators typically cost a lot more.
All right, so I was going to send it over to the tribunal under a special order.
Oh, okay, yeah.
All right. So I'll do a special order. You'll get it from me that sets it up for mediation. Let's see if that works. And of course, you're always on some type of stipulation. I would be willing to sign for other forms of evaluation. But let's begin at that step, and I'll get that order out right away.
Thank you.
So the date that I'm going to have you to return, that's going to be the 20th of March, March 20. And that's going to be at 9:30 a.m. March 20, 9:30 a.m. Will be the final pretrial conference date in this matter. And I'm noting in the file that matter is sent for case evaluation, and I'll issue an order in that regard. So
thank you, Your Honor.
Just to clarify, Your Honor, would the final pretrial conference, will that be conducted via Zoom as well?
Yes, sir. Yes, sir. And you'll receive a notice of hearing in the order that the court's going to issue regarding the mediation as well.
Thank you, Your Honor.
Good day to you.
Thank you, Your Honor. Have a good day.
All right, the court now calls case number 22-191121. This is Modern Financial Service Corporation versus Dwayne McClennan. The matter is before the court, set up for a pretrial conference. The court also notes that there has been the filing of a motion for summary disposition. The filing date with the court is on the 29th of December, pursuant to the court's scheduling order that provides the necessary time period for the matter to be heard on today's date. Your appearance for Modern Financial, please.
Good morning, Your Honor. Naljat Francis, P72322, on behalf of Plaintiff's Attorney of Record.
Thank you, Ms. Francis, and good morning to you. I'm looking for Mr. Dwayne McClennan.
I'm here.
All right, pronounce that last name for me, sir.
McClellan.
McCullough. All right, got
Yeah.
you, sir. All right, and good morning to you.
Good
Today's
morning.
date time set for a pretrial conference date, but also for a motion hearing date. The plaintiff has, sorry, the defendant has filed a motion in this matter indicating, I should say the plaintiff has filed a motion in this matter indicating that there is no genuine issue of material fact, and for that reason, they are asking that the court would enter judgment based upon the motion without any further hearings in this regard. Mr. McClellan, you received a copy of the motion, is that correct, sir?
Yes.
All right, so Ms. Francis, go ahead and tell me why you believe and are arguing that the court should grant your motion at this time.
Thank you, Your Honor. Your Honor, this is an automobile retail installment contract that was entered into on in October of 2020. Defendant does not dispute that he entered into this contract. The defendant failed to make payments as agreed in the retail installment contract, and the vehicle was repossessed and then sold. This is the balance that's remaining after the sale of the vehicle, Your Honor. So there is no issue remaining for trial, and we would ask for a motion to be granted at this time.
All right, Mr.
hear
Mr.
anything.
I noticed that you did not file, or I don't have a written response to the motion itself. But tell me what you wish to tell me in regard to the motion that's been filed in this matter.
Oh, is that? Oh, I couldn't hear you at first.
I was saying the motion that has been filed, I know that you didn't submit a written response, but go ahead and tell me why you believe this motion should not be granted. Go ahead, sir.
Because I bought the car in October of 20. And like around June or July, the check engine light kept coming on, and I kept taking my car back to Legends. And I also had a warranty. I had a warranty, which was RCWS Vehicle Protection Plan. And they only used my warranty one time. And that was because the transfer case had broke. And they fixed that. And then the check engine light kept coming on, and I kept taking my car back to them. And it got to the point where he told me I could take my car anywhere I wanted to. And I went to Star Lincoln Motors, and they told me that they don't take third party no more from Legends, because they got burnt by Legends using this warranty. So my car has kept going on, kept taking it back to them. And they told me that I needed an engine. That was in August 27th of 2021. And when I took my car back 2 weeks to them, because they didn't have, that was the only available time. I took it back to them, and they had my car for a month. And they told me that they changed my engine, which I sent you pictures of my car, and I sent you a video of it knocking. When I got my car out of the shop, I checked it, and I had marked my engine, and the marks were still there, and they did not use my warranty. He told me they put a new engine in my car it was a courtesy. Who puts an engine in a car for a courtesy? That's a lot of money. Plus it was a Lincoln. Then I talked to somebody at Modern Finance. His name was Richard. And I asked him, they came and picked my car up. While I was at work, they repoed it. And in less than a week, they sold the car. They didn't give me a chance to get the money that they claimed that I owe them. I couldn't have been no more than probably about 2 or 3 car notes behind, and that was because I wasn't going to pay for a car that was not running. It was knocking.
All right, thank you, Mr. McClellan. How long was the warranty that you purchased at the time that you purchased the vehicle?
I purchased the warranty at the same time. I was just paying for it within my car note. So I was paying like $525 a month.
So the warranty was for a year, for 2 years, for 90 days, or do you have any idea? Not sure.
It doesn't say. It said, oh, the term was 36 months, 36,000 miles.
All right. All right, thank you, sir. Madam Counsel, in response?
Your Honor, this is for the contract for the loan of the money. Any issues he has with the repairs or the warranty are not relevant to the underlying contract as to the amount that was financed. So, Your Honor, if he has any issues with the underlying dealership or warranty company, those would be separate, and so they are not relevant to this lawsuit.
But I've called Modern and told them, and I asked them, is my warranty still available? And they said, yes, and I said, why didn't they use my warranty? I was paying for it. And they said that you only use my warranty one time, and that was just for the transferring case that was cracked on the car. So, I mean,
All right.
why is it relevant? I mean, I gave you $7,500 down on this car.
All right, thank you, Mr. McCollum. All right, Ms. Francis, you get the last word, if any, on this motion.
I think I'm all set, Your Honor.
All right, thank you. All right, the court has listened to the argument on the motion for summary disposition. The major issue that is raised here is the separation of various interests and parties or entities that pertain to this particular matter. A contractual agreement was entered into for the purchase of a vehicle in relationship to Legend Motors. That vehicle was financed through Modern Financial Services. The obligation that inherent in this matter was for the defendant to pay under the contractual relationship, and that really was not an agreement that was contingent upon whether or not the vehicle would continue to operate, nor was it contingent upon whether or not another party, that is the contracted party with regard to the warranty and or Legend, whether or not they would in fact do diligence. To the extent that they have not or did not do their due diligence, the defendant has a right of action against the warranty company and or Legend for any harm or damage that they may have caused to him. The agreement that Mr. McClellan made was an agreement to pay for the vehicle to Modern Financial Services, which financed the purchase of the vehicle. It does not inherit to them to be responsible for the liability that may exist in regard to the warranty company, or even what activities and actions Legend may have had. He would seem to have, that is, Mr. McClellan would seem to have some right of action to get a refund for the warranty that was not properly utilized, or that they did not tap, or that was a warranty that was deficient or improper in some kind of way, and or to bring an action against Legends to the extent that he believes that Legend somehow deceived him, misled him, etc. But the contract that is on paper is a contract to pay Modern Financial for the money that they paid to Legend to finance this on behalf of Mr. McCullough. I don't see a genuine material issue of dispute as it relates to the rights that inure to Modern Financial by virtue of Mr. McCullough having reached an agreement with them for them to advance money on his behalf to purchase this particular vehicle. And therein is the rub in this matter. You have a transaction that occurs at a particular location with a particular entity, but that entity and Mr. Coleman agrees that Modern Financial will come into it and will pay for the vehicle. That agreement is enforceable, notwithstanding what may have happened in the underlying situation, except in cases where Modern Financial somehow has agreed to repair the vehicle, and that's not what occurred here. Modern Financial agreed to finance the vehicle, and where the vehicle was not paid for, where things fell behind, the vehicle was repossessed. The proper action was to then put the vehicle into the stream of commerce so that it could be sold. Unfortunately, there was a deficiency balance, and the suit is upon the deficiency balance. I've listened to the facts that set forth on this record. I've evaluated the motion for summary disposition. There is no genuine material issue of fact as it relates to whether or not Modern Financial, in fact, finances vehicle, whether they paid for the vehicle, whether the vehicle was repossessed, and whether the vehicle was auctioned and there was a deficiency. On all of those questions, there is no genuine material issue of fact. There's a balance that is due. My determination is that the motion for summary disposition is granted at this time, and judgment will be entered on the motion for summary disposition. That is my order. I'll sign a written order consistent. I do wish both parties well, and good day to both of you. To each side.
Thank you, Honor. We did provide a judgment with our motion.
I do see the proposed judgment. Let me take a look. All right, the judgment, the proposed judgment does conform with the prayer of relief that is contained in the complaint. So the court will enter the judgment at this time. The total amount is $6,026.45. And both sides will receive a copy of this order in the mail in the next few days. All right, I do wish you well. Good day to both sides.
Could I ask a
Yeah.
question? Judge,
Your
may I
case
ask
is
the
open.
question?
Yeah, go ahead.
Oh, I was just wondering, well, okay, since this case, can I go after Legends Motor?
You have to consult with a lawyer. It sounds like you may have a right of action as it relates to Legend and perhaps as it relates to the warranty company. But again, that's something you want to consult with a lawyer and see what you can do in that regard. The problem, of course, in your cases, as it is in so many cases, is that the financing agreement is separated from the place you purchased and everything. The finance agreement was with Modern Financial, and that's why the order was granted in the way that it was. I would love to be able to share more with you, but I have to go on to some other cases. I do wish you well, Mr. Bell. Good day to you, sir.
Okay, thank you.
Thank you, Honor.
Thank you, Mr. This is case number 22-19170. Strike that 50. This is Farmington Diamond Associates LLC versus Stephanie Watkins. The matter is set on for a status conference. I received the defendant's answer to the complaint. The complaint alleges damages, it seems to me, in the amount of $1,487.02. Your appearance for the plaintiff in this matter, please.
Yes, Timothy Frost on behalf of plaintiff, Your Honor, P40616.
Thank you, Mr. Frost, and good morning to you, sir. I'm looking now for Stephanie Watkins. Ms. Watkins, good morning to you if you're there somewhere. Good morning, Ms. Watkins.
Good morning, Your Honor.
Thank you, ma'am. I've received your answer. This is something about regards to the amount you said, the apartment complex state. You said you moved with your father to Texas. You said rent was never late. Unfortunately, your father passed away. It seems like what this is about is that they're suing you because there was some type of lease agreement that would have allowed for additional rent after you moved out of the property. Is that? Let me ask Mr. Frost. Is that about the size of it, sir?
That is correct, Your Honor. I was looking at her answer while I was waiting, Your Honor. If you read it, it looks like she went to our client and let him know, hey, I'm going to be moving out because my father died, and they agreed on a move out date. but there's nothing in the answer that indicates that she was released for the couple of months that were apparently left on the lease. I don't see anything there about her being released. So it seems to me she'd be still liable for those sums. And we're not talking about a big amount. We're talking $487 and then some court costs.
Well, looks like the complaint says 1,400. Are you saying?
Yeah, 1487. I'm sorry, Your Honor.
Have you had an opportunity to talk with Ms. Watkins to see whether or not you might be able to reach some accommodation to resolve this? Ms. Watkins, before you answer, Mr. Frost, Ms. Watkins, the issue here becomes if there is a lease in place, then even if there was agreement for you to move out at a certain date, unless you have something in writing that releases you from the balance of the lease, then you'd still be obligated for months that might remain under the lease. Of course, the plaintiff would have the duty to try and rent it out as soon as possible. But until they rented it to someone, you would have an obligation that remains even if you move out of the property. Go ahead and talk.
Yes, sir. I do understand that, Your Honor. I went into the office several times and I talked to the manager. We sat down at the desk. I explained the situation. My lease was going to be up in like a month. And I explained to her that my father was going back to Texas. And after my lease, I just wanted to be there a couple of more months. She sat down and she keyed in all the information, how much more I would have to pay. And what we came to agreements, and she stated the 9th. She said you had to be out by the 9th. I said, great. And then after we continued to talk, and honestly, I do remember things on paper. I don't remember taking anything out the office. I really don't. But my understanding that I was supposed to leave on the 9th, so I went into preparation. I packed up everything. On the 7th, I thought I smelled some gas, so I called the office. The maintenance man came out, and that's when he said, oh, you're moving. And I said, yes, I'm leaving on the 9th. He went back to the office and I guess he told them or discussed it or whatever. And that's when I started getting calls from the manager stating why you didn't tell us. And I said, I thought that's what the meetings were about in the office. You told me the 9th. So I was leaving on the 9th, but I paid them up to the date of the 9th. I had a zero balance, I thought, when I left. So I was very surprised when I got this $1,400 letter stating that I owed them. And they said I didn't tell them when I went in the office several times and we talked about it. And she keyed it all in. She told me how much I had to pay a month extra. So I'm just kind of lost on this.
All right. Well, it might help. It might help for the two of you to talk in the breakout room to see if you can go over some of this and figure this out. Unless you, the challenging thing, Ms. Watkins, is of course having a written document that tells what the parties were going to do if there was any change in the terms of lease would be critical. But why don't the two of you take a moment? I'm sending you a notification for breakout room and see if you can get it resolved with some accommodations in this regard, and then you come back into the courtroom. So I've sent you a notification, Mr. Frost, Ms. Watkins, for breakout room number 1. Go ahead and see if you can talk about this. And when you come back in, I'm going to keep this file in front of me and see if you can get it resolved, and we'll talk about it on the other side.
Thank you, Your Honor.
Go ahead and click in. All right, the court now calls case number 22197491. This is Crystal Langsford versus Paisley McGee. The matter is before the court set on for a status and scheduling conference relative to a complaint that was filed alleging that there are damages in this matter I've received the answer as well in this regard. All right, do I have Crystal Langford on the Zoom?
Yes, it's Christine Langford.
Thank you, Ms. Langford. And I like Christina, but I'm glad I don't have to say it 5 times in a row. All right, good morning to you. I'm looking also for Paisley McGee. Are you there?
I'm here.
All right, good morning to you, Miss McGee. All right, Ms. Langford, look like this is something where you indicate that something about the poisoning of your dog, a German Shepherd. Is that correct, ma'am?
Actually, 2 German Shepherds, and then there was a secondary call made on June 26th to the Detroit police in regards to attempting to petition me. So initially, when she came to my home on June 21st without having any contact since December, she, within 2 minutes of her arriving, she advised that she was going to call 911, came back, said she was going to call animal control, which I have submitted discovery to both the court and Miss McGee. I sent the Ring camera footage and other social media videos were over the limits, just actually emailed those in. So I mailed those in on January 6th via certified mail to both of you guys.
All right, so let me ask you this. I don't see where you've placed any petition or prayer for relief in your complaint. What are you asking the court to do, Ms. Lang?
I am requesting $25,000 in regards to the poisoning of my animals, destruction of my property, because as a result of the gallon of water that was poured on my floor, I had to peel that up. And also in regards to the 2 false police reports that were filed against me.
Well, let me ask you, you say that false police reports were filed against you. Was any action taken against you?
The second incident on June 26th, there were 6 Detroit police officers that arrived to my home for a wellness check, which I also have the 911 call from Miss McGee. The initial 911 call from June 21st, the FOIA request is still pending.
All right, yeah, that's none of that is going to be anything that is actionable here. If you were arrested or somehow apprehended or something, that'd be a little bit different. All right, so let me ask you about the dog. What happened to the dogs now?
Both of the German Shepherds, the first one, the younger one, Isis, she started throwing up that morning when I got home around 7, 8 a.m. The second German Shepherd started vomiting the next day, which I did take them to the vet, and I was referred to a specialist.
All right, and how are the dogs now?
They're fine.
All right, how much money have you spent at taking them to the vet for care?
I did not have the funds to actually take them to the specialist. I did reach out to the Humane Society, but I was considering surrendering my animals as a result of her actions. She is continuously, I'm sorry, go ahead.
Have you surrendered your animals?
Not as of yet.
And you said they're doing well, they're doing okay?
Yes.
Okay. All right, and so what is this about the what is this about the floor? You indicated that she poured some water, and what happened?
There is peel and stick floor in the area that she poured the gallon of water in. I think it was about 1.5 gallons. That had to be pulled up. I have the replacement floor, which was $50. I have not had it installed as of yet.
How much was the replacement floor?
$50. It was peel and stick, $50.
Gotcha. Did you have someone to do that work, or are you?
I've got a contractor set up. I'm getting all of the entire floor done, so they're going to do that this time.
So, but
Are you ready?
I put in at 10:50.
you're saying that portion is going to cost you about $50 to get it done.
That's for the flooring itself. I say for the actual installation, it's about $150.
So I know that you, today is not the trial date, but it looks like this case is something that should be resolved, because it seems like the harm, perhaps even intended, never really occurred.
I apologize, Your Honor. I actually disagree because I'm sorry.
Of course you disagree, but I didn't ask you whether you agreed or not. Let me go to Ms. McGee at this point. I'll come back to you in a moment. Ms. McGee, So what is going on with this? She says she has some video with you poisoning her.
Yes, I heard. Excuse me. So, just to correct the dates, because she said June 21st, on June 18th.
Stop you for a moment. I don't care about the date and stuff, but are you, did you put something down that allowed her dogs to get poisoned?
Oh, no. To answer that, no.
All right, so if there's some video that's been offered, you're saying it would not show anything on video where you put in anything that has to do with any poisoning regarding the dog, correct?
Correct.
So you had some connection to Miss Langford whereby you came to her home a couple of times, is that true?
Yes, I'm her first cousin, and we were doing a mental health check, and I also have a witness, the higher advocate, mental health advocate, that's on a Zoom call right now too.
Let me stop you for a moment. You know, with all due respect, I don't care about that. You know, I'm not interested in that. Let me ask you.
Okay.
You called law enforcement a couple of times to come to the home because you, as you stated, I believe that you thought that there were some wellness issues that were involved. Is that correct?
That's correct.
Did they arrest or take Ms. Langford to jail or prison or to a hospital or anything along those lines?
No.
So she says that you poured some water somewhere that caused some damage to her floor. What about that?
I actually have water bowls, and I do if the court needed, but I pour excuse me, water in water bowls, and that's how the dogs actually had water, and then the water spilled on the floor. And I have videos where she showed and posted on of like the waters being on the floor because they knocked over the water bowl, and she said she'll mop it up. So.
All right. She says that it caused some damage to some towel and that it would cost $150 to repair that. You know anything about that?
I know nothing of it. I just know of damages she had prior to, and she posted that, and I have that evidence if needed.
All right. Thank you very much, ma'am. What do you think this case is worth? What do you think you will in this case?
I absolutely don't think I have to distribute anything out of wellness, and also I did not poison nor damage her floors.
Thank you very much, ma'am. All right, Ms. Langford, so you have, so you said that you have her on video poisoning the dogs?
Yes, I actually have her and her girlfriend that actually came to my home. My dogs have sensitive stomachs. She brought them some unknown brand of dog food, also strawberries. There's also video footage of her actually pouring a bottle of water on the floor. And I actually still have the dog food that she opened my windows and pushed into the house. She initially came to my house under the impression that I was abusing and neglecting my animals.
Yeah, and I've heard you on that before. But let me ask you this, man. The dog food that was given to your dogs, did you have any of that tested to determine whether or not there was something that was intentionally placed in the dog food to poison your dogs?
No, however, you cannot switch a dog. You cannot change a dog's brand of dog food without it being done incrementally, without it making them sick. Not to mention, I'm sorry, I apologize, Your Honor. Not to mention, I don't know.
I turned you, I shut you off because when I'm talking, you can't talk. The bottom line here is that you likely do not have a cause of action in relationship to her offering food to your dog. And you certainly don't have a cause of action for $25,000. Here's what I'm going to do. And you may have something as it relates to the condition on the floor. You've indicated that that's about $150. So what I'm going to do is I'm going to set the two of you up to come and talk to me next week on the Zoom hearing next week. I'm going to treat that as a trial date. The issues have been narrowed in this case based upon what both of you have described. This is not a case of quote unquote poisoning dogs and turning people over to police. That's not what this case is about. But you've already indicated to me on the record the parameters of this case. I'll allow you to talk to me under oath.
Your Honor, may I speak? I'm sorry.
Not until I'm finished talking.
I didn't know if you were. That's why I asked. I'm sorry.
No, if I'm finished talking, I think you'll know exactly when I'm finished talking. I think you'll know it. But I tell you what, go ahead and tell me what you want to tell me. Because obviously you want to interrupt me. I have a courtroom full of people and I'm trying to move through this expeditiously. That's the whole issue here. I've listened to you extensively. Tell me what your case is about, but you still want to talk.
Sir, I was asking if I could speak because your audio was cutting out. That's why I was asking.
It's
My
not
other
that.
cons-
There's
okay.
been no you speaking when I gave you opportunity to speak. There's been no problem with that. It's only when I'm speaking that you then have a problem with whether or not I'm done speaking. I wonder how that's the case. And the reason for this is because I've got a courtroom full of other people. I've allowed you to talk. You want to interrupt me when I'm talking. That's incredible to me. Now you have something else. Tell me what else you want to tell me after you've been given ample time to talk. Go ahead and tell me what else you want to tell me. I'm listening.
Sir, I was actually going to ask if it was okay if my witnesses spoke in regards to the harassment that has occurred regarding the social media posts that I've been making, and also the false accusations of her doing wellness checks and using the police as a third-party method in regards to stalking and harassment. So I apologize. That's why I was asking if it was okay if I spoke, because like I said, your audio was cutting out towards the end. So I was not sure if you were completed with your sentence. I'm not trying to be disrespectful. I'm trying to understand what are my options in regards to preventing my family from coming to my home, bothering myself and my animals. What are my options to protect myself? Because I've already attempted to file a PPO request. That was denied. I've already filed a complaint with the Office of the Chief Investigator in regards to the way that the situation was handled with the dogs. I can go ahead and get the dog food tested. If I have not spoken with someone since December, there is no reason for them to be coming to my home feeding my animals.
All right, I hope that you're done at this point, and said everything that you perhaps desired to say. The reality of it is that you likely do not have a cause of action. You've indicated that you've gone to try and get a PPO and things along those lines. That would be a wise and appropriate approach to take. And if the court did not find a reasonable basis to grant you a PPO, then perhaps you gather some other facts and take them back, and you could achieve a PPO. The information has been provided to this court based upon my 37 years of experience and 30 years as a judge. I don't see a cause of action here except on the narrow stuff that I mentioned to you. That's just honest and straightforward, because I don't have time to waste with cases. If you got something, then you got something. It sounds like and it sounds like there would be a reasonable basis to go for a PPO to try and get people saying that's not something that's actually and this court does not have jurisdiction to have the jurisdiction in order to say as a person can't come to your house or so on and so forth. So that's a challenge here. Of course, you would not know those parameters, but at the same time, those are what the facts are based upon what Ms. Langford told me, as well as what Ms. McGee told me. Most of my determination as to what this case looks like is based upon what Ms. Langford told me. I think that she was forthcoming. She told me the truth about what occurred. And if she tells me the truth about what occurred, then if I take it in a light most favorable to Ms. Langford, it does not look like she has a cause of action, except as it relates to some damage that may have occurred to the floor. But again, I'll give opportunity to air it out a little bit. I'm going to set this up. Let me give you a firm date so that you can come back and I can hear this. And I've already heard most of it, but I'll hear some more of it. And let's set this for the, Madam Clerk, can I see what on the 26. 1/26/23 at 10:30 a.m. 1/26/23 at 10:30 a.m. That is a trial date. The issues are narrow in this case, and I'll hear the issues. Expect that I'm going to cause you to go straight to the point. You won't get to wander all over the place because I don't allow that. All I allow is relevant evidence. And again, your relief on either side here may be otherwise. And I think that Ms. Langford pointed out a part of that, and it's unfortunate. I think that these parties clearly need to stay away from each other. Ms. Langford don't want to be bothered, and if somebody wants to check on her, she don't want to be bothered with that. But that does not give rise to a cause of action for monetary damages. That's the problem here. All right. So I'll see you on the 26th at 10:30 a.m. Good day to both.
Thank you, Judge.
With apologies, I'm back to Farmington versus Watkins. Are you there?
Yes,
Yes, Your Honor.
yes, Your Honor.
I know you guys didn't expect me to come back, but I told you I would. 1750.
Yes, you did.
You did, Your Honor.
1750 is the suffix on this case, Madam Clerk, Madam Court Reporter, I'm sorry. All right, Mr. Frost, update me if you will.
Yes, Judge, we did have a chance to speak. We were unable to reach a resolution. And I think the court is well aware of the issues. At this point, Judge, I just asked for a date for a motion for summary disposition. We'll just file a motion and try to dispose of the case in that fashion.
All right. Ms. Watkins, anything you want to say? I know you took a chance to try to get this resolved and was not able to do it. The typical process would be for the court to set up some type of schedule in the matter at this time. Anything you want to say finally, Ms. Watkins?
Yes, Your Honor. I would like to say that I paid my rent. The last time I paid my rent was the 1st of February, and I left on the 9th of February. So I was paid in full. I mean, I paid them in full. You know,
Right.
so I don't. Yeah, that's it.
All right. Thank you very much, ma'am. I am going to set this on a 60-day scheduling order. That would bring the matter back before this court. Actually, just a little bit short of 60 days. So I'm going to set it for March 16, 2023, and that's going to be at 9:45 a.m. March 16, 2023. Any motion that a party may wish to file can be heard on that date, so long as either side file their motion with the court at least 10 days before the hearing. In other words, you have to give notice to the other side at least 10 days before the hearing, and I'll hear the motion on the 16th of March. During that period, this interim period, the parties may exchange information. They engage in discovery, meaning that the parties can demand of the other side documents, information that the other side may have. All you need to do is put it in writing and request the documents. So, for example, Ms. Watkins could put in writing a request for all documents that the plaintiff intends to rely upon in prosecuting this case, and they will have to turn those documents over to her. Likewise, the plaintiff can send questions, request to admit various documents, requesting information from Ms. Watkins during that period of time. And so that's the process of discovery. And then the 16th will be the pretrial conference date, but it's also a motion hearing date. You'll see under the order that I'm going to send you, under paragraph number 6, it will provide that either party can file motions, dispositive or otherwise, and set it for hearing on the 16th, as long as you give the other party at least 10 days notice before the hearing. That will all be in my order that you'll receive from me in the next few days. All right. I do wish both sides well. Again, 3/16/23, 9:45 a.m. That date will also be in the scheduling order as the next action date. I do wish you well. Good day to both.
Thank you, Your
so
Honor.
much, Your Honor.
Thank you. Good day.
Have a great day.
Likewise. All right, the court now calls case number 22-242-553. This is Cynthia Rufus versus Redford Auto Repair. The matter is before the court, set for a pretrial scheduling conference. Set for a status and scheduling conference. It looks like this is the first date upon which this is before the court, I believe. All right, your appearance for the plaintiff in this matter, or do I have Cynthia Rufus?
Yes, I'm here.
Good morning to you, ma'am.
I'm sorry.
I said good morning to you.
Oh, good morning. Good morning.
All right, for Redford Auto Repair, who's here?
Morning, Your Honor. Robert Akuri appearing on behalf. We filed our appearance. We set aside the default. We gave cause for the court. We need a status conference and some discovery, Judge.
All right, thank you, sir. Your P number, if you keep this record, Mr. Curry.
Yes, Your Honor. P43788.
All right, very well. So what is being requested here, Ms. Rufus, is that the court set up a schedule on this case. And then that schedule would allow for the parties mutually to engage in discovery, to discover any and all documents, information that the other side may have in advance of this matter proceeding to a trial setting. It also will resolve the court issuing a scheduling order that allows for the parties to file motions if they wish to do so within the time frame that the court will provide. Anything you wanted to say to me at this time, Ms. Rufus, before I set this case up?
Yes, this originally was in small claims court, and I had provided my evidence to the small claims court. So I'm not sure, should I submit that again, or I'm not sure how that works.
If you submitted your documents via the port that was allowed with the case number on it, you should not have to submit it a second time. Okay.
Well, Your Honor, I'm still going to need to see that documentation with my discovery. So I don't want her to misunderstanding that she doesn't have to give it to me.
Yeah, well, both sides, as I've indicated, you'll receive an order, and if the attorney gets something from Ms. Rufus saying, I need copies of your documents or anything along that line, Mr. O'Curry's office will have to supply that to you. Likewise, Ms. Rufus, if Mr. O'Curry's office sends to you requesting documents that you may have submitted to the court or otherwise, requesting information from you, you have to comply with that and submit information to their office. If they request such information, it will have to be in writing. So over the next roughly 60 days, that is until the 16th of March, discovery will be open in this matter, allowing the exchange of information between the parties during that time frame. I am setting a hearing for 3/16/22. That's going to be at 10 o'clock a.m. 10 o'clock a.m. 3/16/22. And you'll receive a copy of these of the pretrial scheduling order from this court. And I do wish you well until I see you the next time. Good day to both.
Your Honor, thank you so very much.
Can I ask a clarifying question?
Yes, ma'am. Go ahead, Ms. Rufus.
Okay, so you're saying, I just want to make sure I understood what I'm supposed to do. So you're saying I submitted my evidence when it was in small claims court, and now I need to take that evidence and forward it over to the attorney?
No, what I'm saying to you is that whatever you submitted to the court, that's what you asked me about. If you submitted it through the port with the case number on it, then you should not have to resubmit to the court. Submitting something to the court is different from the parties exchanging information. Now that this case is set on a discovery pathway, you are required to submit documents to Mr. O'Curry's office, maybe what you've already submitted, and in addition, other documents that they may ask of you with a written request. You also can request in writing from Mr. O'Curry's office any documents that the defendant intends to use or that they believe support their side of the case. So mutually, over the next 60 days, both sides have the right to request documents that the other party intends to use. So that's a whole new process. The submission of evidence to the court is a process that is different from what we're talking about now. The process now is exchange of information between the parties. You understand?
Yeah, so I should wait for him to request that? Is that what you're saying?
Request it, or you can voluntarily send it. Either way, you know you're gonna have to send that information. Typically, it's a requested information, but again, the parties you expedite things when people simply exchange information. The court is going to issue an order for it, but whichever way you do it is whichever way you do it. I just want you to see this distinction between submitting something to the court and submitting something to the other side. To the court is one thing, submitting between the parties is something else. Okay?
Okay.
All right, I wish you well. You'll order in the next few days. Good day to you.
Thank you.
Thank you, Your Honor.
Thank you. The court now calls case number 22-242, strike it, 24-24-29-6. This is Darren Pendleton versus Hester Wheeler. The matter is before the court. Looks like set on for, I know there was a motion for a more definite statement that was filed in this matter. And the court did issue its order on December the 12th in that regard. And I set the matter on for pretrial on today's date. Are your appearance or do I have Darren Pendleton on the Zoom or counsel, Mr. Pendleton? Go ahead at this time.
Yes, I'm on the call.
All right, thank you. That's Darren Pendleton. Thank you, Mr. Pendleton, and good morning to you. For defendant Hester Wheeler, counsel.
Judge, good morning. This is Brian Beach, P69681 from Michigan Attorney General's office on behalf of the defendant Hester Wheeler.
All right, thank you, counsel, and good morning to you, sir. So update me on where things are at this point regarding this matter, counsel.
Yes, Judge. So the court's correct. On December 12th, you granted our motion for a more definite statement. On December 22nd, I don't know if it was filed with the court, but we received a paper copy of what appears to be an email from Mr. Pendleton. This is the only document we've received. We didn't ever get any type of amended complaint. It looks like this is meant to be a complaint. But I don't know, again, I don't know if the court has a copy of this, but it suffers from the exact same defects as the complaint that he filed in small claims court. I believe the court is probably going to recall that at the previous hearing, you did instruct Mr. Pendleton about what needed to be included in the complaint, things like dates, about specifics, about what about what he was alleging occurred involving the Secretary of State, about what the defendant, Mr. Wheeler, did. And this email that we received, it doesn't include any of that, Your Honor. It's just as confusing as the complaint that he filed in small claims court.
All right, and it looks like the document that you may very well be referred to, it says, I am Darren Bernard Pendleton, the plaintiff in this lawsuit is against Lieutenant Wheeler in official capacity of Michigan Secretary of State, suing amount $100, rights under common law and equity relief, non-jurisdiction passport, lawful document, law enforcement agencies to travel without driver's license and license plate and insurance information for automobiles or any other traveling destination would have been resolved by issuance of such passport. The undersigned square under penalty of perjury, the foregoing is true. So that's a document that you're referring to that you received, Mr. Beach?
That is the document that I received, Your Honor, yes.
Right. So so what is your cause of action, Mr. Pendleton?
Pardon me, sir.
Yeah, what is your cause of action? What enforceable what is it that is enforceable at law that you're asking that this court do?
It's enforceable in law as far as Hercules versus California, that the state cannot diminish the rights of people and provide me with a passport so that I can have lawful documentation to provide to law enforcement officers when I get stopped.
So you made an application for some type of passport with the Secretary of State's office?
Yes, I did, sir.
All right, and what happened with your application?
They didn't respond back to me.
All right, Mr. Beach?
Judge, I don't know what type of passport. I mean, I don't really know how to respond to that about what I don't have any record of that. I don't know what Mr. Wheeler would have done at all in this case, to my understanding. I would note for the court that we did file a motion for summary disposition on January 3rd in response to this amended complaint, if that's what we're going to call it. And, you know, again, there's a complete failure to state a claim here in terms of what exactly is being alleged. Again, I don't know what kind of passport would be issued by the Secretary of State that he's referring to.
All right, and you did not, Mr. Middleton, you did not include a copy of your application for any passport with your purported answer, correct, sir?
Sir, I did include in my documents with court the evidence of me applying for a passport, and I applied twice, and that was in original files. I did include evidence of that with court. So I also sent Mr. Wood lawful decree ordering him to issue a passport to me.
All right, and are you talking about a U.S. passport, sir?
Yes.
And you know that a U.S. passport is not issued by the Secretary of State of Michigan. You know that.
I know that that the Secretary of State can't intervene upon my decree to take me a passport.
I don't see a cause of action here. I don't see any cognizable action that wherein this court could grant relief as against an agent of the Secretary of State's office for a petition for issuance of a passport. And one of the things that would have to occur, of course, is that there would have to be the showing of the denial of any kind of application that was made, the basis upon which application was denied and or should have been granted, in order for there to be something that this court could advance, allow a cause of action to be advanced. There simply is no basis upon which relief could be granted in this matter. Moreover, the complaint that is issued is deficient on its face. I don't see any basis for the relief that you seek herein, Mr. Pendleton. For that reason, I will grant the motion for summary disposition in this matter, finding that there's no cause for relief in this matter, and that the complaint is otherwise totally inefficient to state a cause of action before this court. The case is dismissed accordingly. If you come up with what it is that a cause of action that you could advance, you can always refile and advance it. But what you presented to the court does not present a cause of action. The case is dismissed.
Thank you very much, Your Honor.
Thank you very much, Your Honor.
Thank you, sir. Thank you for your patience on Beaumont versus McGowan. This is case number 22-194-774. The matter is before the court, set on a status and scheduling conference. Again, thank you for your patience. We're running behind time for sure today. Your appearance for Beaumont Health, please. Mr. Burke, I see you there. Your appearance for Beaumont.
Can you not hear me, Your Honor?
Now, so your appearance at this time?
Can you not hear me?
I hear you now, Mr. Burke. Can you hear me okay?
Yes, sorry about that. P69068, Attorney Hal Burke for Beaumont Health on this case.
All right, thank you, Counsel, and good morning to you. I'm looking now for the Portia McGowan. If you're on the Zoom, please say something at this time.
Good morning, Your Honor.
Good morning, Ms. McGowan. Of course, it's good to have you here. This is a cause of action where the plaintiff alleges that there's damages in the amount of $2,862.05. And I did receive your letter that the court has treated for this time as a response. So you indicated that you received the documents that, what is it, you're telling me that you've been trying to get this worked out, is that what it is, ma'am?
Yes, sir. I actually set up a payment agreement of $50 per month. It's going to come out on the 30th of every month, automatic withdrawal from my account. Since I sent that letter, I did receive a response with the breakdown from Beaumont and from the attorney's office, I'm assuming. With what I owe, I do agree with the full amount. I don't see any reason for me to disagree with it.
Your Honor, if I may give an update as well, and I appreciate what Ms. McGowan said.
Go ahead, Mr. Burke. Yes, sir.
On November 21st, we emailed Ms. McGowan, and she is current in her payments. We emailed her a proposed consent judgment for her to review and sign and get back to you. We have not received it back from Ms. McGowan. I'd ask if she did receive it. I won't say her email address on the record if she doesn't want me to, but we do believe we have the right email for her. That would dispose of the case.
All right.
In response, I'm sorry, Judge, Your Honor, you go ahead.
I was going, oh, thank you for the permission to go ahead.
I'm sorry.
I'm just, but listen, it sounds like you got it worked out, but they're waiting for a document. So all of this is put in writing, and of course, you're already paying under the terms of the agreement. So go ahead. What happened with the document?
I did not receive well, I won't say I did not. I haven't seen an email. However, I did receive something in mail. In the same day that I received it in mail, I received the court appearance letter. So I didn't know if I should mail it off or not, but I'll get that in the mail today.
All right. Yeah, that's yeah, they just kind of overlapped it. It seems to me. All right. So what I'm going to do is I will go ahead and indicate that this case has been resolved. And what I'm going to do is I'm going to put it over for 14 days awaiting the order. So you need to get that back to Mr. Burke, and then Mr. Burke will get it to the court. So I'm going to set it over for review. And I'll actually just 1 second here. Let me see where I am. I'm actually going to put it February 1, 2/1/23. I'm going to give that time to get the order into the court. If there's some problem, I'm going to set this on now for 9:45 a.m. If you send that document to the attorney, that's not a date that you have to show up for. But if for some reason there are problems, parties will need to show up in front of me February 1st at 9:45 a.m. I expect to have a written document by that time.
Your Honor, may I make one additional suggestion on your good idea? May I give Ms. McGowan my email? If she's able to email it to me, I could get it to the court today. I don't know if she has the ability to scan it and email it back after she signs it.
Perfect. Why don't I do this real quick? Why don't I put both of you in a brief breakout so that you can kind of work on the logistics. So I'm going to send you that notification. So you got a notification for breakout room number 2. All right, and I'll await the paperwork. The two of you can talk. Go ahead and click in.
Your Honor, may I get your email, your court's email also, if in case she can send it to me?
That's go ahead. I'm going to give you the email address. My clerk is holding on to several files from Mr. Burke, and haven't received the closeout orders on them. She wanted me to make sure that she knew. So Mr. Burke, her email address is Carmen. First name is Carmen, C-A-R-M-E-N. Banks is the last name, B-A-N-K-S. At 36districtcourt.org. Carmen.banks@36districtcourt.org. And Mr. Burke, she says she's waiting on several orders from you.
I will send her an email Thank you, Your Honor, and we try to send as quickly as we can. I will, if it's okay with Miss Banks, I will email her and ask her which ones she's waiting on, try to get them all to her in one time.
Sounds perfect, sir. All right, I'll talk with you soon.
And Your Honor, I apologize. I do have one other case with you right now as well. Would you like me to go in the breakout room, or do we want to call that second one too? Whichever you.
Go ahead to the breakout room, and as soon as you come back, I've got that one. I'll call it as soon as you're back.
Thank you. Could you send me back into that breakout room?
That's number 2.
Number 2.
Yeah, do you see it there?
Yes, I do. Thank you.
Go ahead. All right, this is case number 22197357. This is Cash LLC versus Diana Morton. I'm sorry. The matter is before the court set on for a pretrial status and scheduling conference. The court did in fact receive a response to the complaint in this matter. Do I have plaintiff counsel, please, your appearance?
Judge, may it please court, I am Attorney Richard Wilson, my bar number 35222. I'm the attorney of record for the plaintiff, and I'm the attorney for the plaintiff in this pretrial conference.
All right, thank you, counsel. Good morning to you, sir. I'm looking now for Ms. Morton, Diana Morton.
I'm here, Your Honor.
All right, good morning to you, ma'am.
Good morning.
All right, so I do see the answer filed in this matter as well as affirmative defenses. And let me hear from counsel. Can you update me? Has there been any discussions or anything regarding this matter?
Well, I can update you. I don't know about discussions, but I can tell you, Judge, with Ms. Morton, that apparently from the plaintiff's records, Ms. Morton had sent in several years ago a fraud affidavit. She claims that there is some fraud or identity theft. I have reviewed prior to the case being called her affidavit of identity theft or fraud. She attached a police report, but the plaintiff at that time found that there was not sufficient corroborating information other than for what the attorneys would call a bare bones application. I have a recommendation. The recommendation I have, Judge, is to have a short period of discovery for 60 days, and I will send, I will tell the court now so you can prepare it. I need to have her produced to me by a production document request, proof that she has been a resident at her Detroit, Michigan address, which is in the court register of action on Glastonbury Road, all during the times of, I think, 2016 or so, when this web bank loan was taken out. I mean, that can be some things like redacted copies of her income tax, DTE bills, a copy of her deed, something that verifies that at all times relevant, she's been a resident of Detroit and not to the address where the plaintiff's, I'm sorry, the original creditor's statements went to from WebBank. I can tell you that I'm not exactly the Buddha of law, but I've seen these sort of matters before, and I think I know, as the plaintiff's attorney, how to get right to the heart of the matter. And on that, I rest.
So, Ms. Morton, the heart of the challenge that you bring to this is that you believe that this has to do with identity theft and with a fraud claim, a complaint that you filed or a report that you filed at some previous date. Is that correct, ma'am?
That's correct.
All right. So the other side wants to, as a court would normally allow, to have a process of discovery in this matter for the exchange of information. And Mr. Wilson, who is the attorney for the plaintiff in this matter, has indicated that there was some specific information that he'd like to receive from you relative to your residence at the time that this claim allegedly arose. Apparently, there may be some information that, to the extent that that is the case, that this may have some impact upon the claim that they brought against you, alleging that there is some indebtedness. Anything you wanted to say to me before I set that schedule up, ma'am?
No, Judge, yeah, I'm sorry.
I'm sorry, Ms. Morton, I'll come right back to you, Mr. Rosen. Ms. Morton?
No, it's just that I had questions too pertaining to this, as far as finding out. This has been since August of 2015, and I do not have any specifics on it. So I'm sure that getting with this attorney, we can work out getting this paperwork, because I don't have any information as when this money was deposited in my account, or I don't have anything like that. And I know this company asked me to file this report, and I did send it in. They asked for a signature analysis, which I also sent in, and I never got any response from that. And I also I have this account with Lexington Law, and they work on my accounts that are on my credit report. And I understand when I talked to them yesterday that they are working with this company. So I don't know what all of this is involved.
All right, Mr. Rosen, you were going to say something, were you, sir?
Oh, no, when you asked if there's anything else, I was just going to say no, the plaintiff rests, Judge, but I will conclude again briefly. As Ms. Morton says, again, I would invite Ms. Morton to work with my office. She should call, if she has a pencil, call extension 2200. When she calls my landline, that's one of my best staff persons, David, who's just 10 feet outside my door. And that way, I think we can get down to the heart of the matter. As I said, I just need proof of her residence, since, 2015. She says, hey, I've been here for 20 years. I don't know what Bruce is talking about. I get that. But I need to show the plaintiff so that we can get to a happy resolution and hopefully just close the matter out entirely.
All right. So what I'm going to do is I'll go ahead and set it up on a pretrial scheduling order and give the parties opportunity for exchange of information, try to resolve some questions, and perhaps that will lead to a resolution of the case. I will go ahead now and send it over for 3/20/23, and that's going to be at 9:30 a.m. 3/20/23 at 9:30 a.m. I will allow for discovery through that date. You'll receive an order from me in the mail allowing for discovery through that date. And this is to allow the parties to exchange information. And I look forward to seeing the two of you at that time, or perhaps not, get it resolved. And then that date will not apply. You'll just send in some paperwork and the case will be all resolved. So you'll get some paperwork from me with that date on it in the next few days. I wish you well, Ms. Ward. Thank you, Mr. Wilson. Good day to both of you.
Thank you.
Thank you, Judge.
This is case number 22-197-965. This is LVNB Funding LLC versus Andrew Jones. The matter is before the court, settling for a status and schedule conference. There was an application for entry of default judgment. Your appearance for LVNB Funding, and Mr. Burks, I'll be right with you, sir. Your appearance for LVNB Funding, please.
Yes, ma'am. Please, court, Your Honor. My name is Attorney Richard Rusin. My binder is 35222. I'm the attorney of record with the plaintiff. I am also the attorney appearing on behalf of plaintiff today at this status conference.
Thank you, counsel. Good morning again. Looking for Mr. Andrew Jones. If you're on the Zoom, say something at this time, sir.
Yes, Your Honor, I'm on. Yes.
All right, thank you, Mr. Jones, and good morning to you, sir. And thank you for your patience. You're not a lawyer, so you're not used to waiting in court, but you get a chance to experience that this morning. I have received a copy of your answer, and I know that this case is based upon a claim for damages at $1,096.07. So I don't think the parties have had a chance to talk at all on this. So what's your challenge to this, Mr. Jones?
Well, first of all, I just want to get some clarification because I had filed for bankruptcy in 2015. So I want to get the date.
Well, initially, let me just look at that. If defendant filed for bankruptcy in 2006, that's a long time ago. I can tell the court, one moment, please, that the credit card bills I'm looking at, oh, by the way, I showed the defendant had a Chapter 13 bankruptcy. The case number in the bankruptcy court was 2044282. That was filed on March 23, 2020, but that bankruptcy was dismissed on April 12, 2021. So with the dismissed bankruptcy, these are credit card statements that were incurred within 6 years of the summons being issued here. So I think the bills are justified due and owing.
Okay, I agree.
Yeah, I think that's what he was referring to. I think Mr. Jones was referring to that 2020 bankruptcy that was filed, and that was a Chapter 13. Ultimately, that one was dismissed, and it would not apply to this matter unless there was some type of discharge that was granted. If they dismissed it, they didn't give you a discharge on this particular file.
Yeah, and just so Mr. Jones is clear, these are, I'm looking at about, 30, 25 statements from Credit One Bank. And so they were, payments received, charges made, et cetera. So I can talk to Mr. Jones. I see that his answer to the complaint actually admitted everything. I don't think there's a dispute. If Mr. Jones is just simply in a position to make installment payments, I can certainly entertain that quickly and at this time.
Yes, that's next thing I wanted to ask, because on disability, I'm on this fixed income, but I was hoping that we can work out an arrangement where I can pay the minimum amount.
All right, I think that a breakout room would be appropriate at this time.
Yeah, I'm going to send the two of you so that you could talk about it, Mr. Jones, and see if you can get something worked out here. It seems like a case to do that, and I think there may be a reasonable case. So let me go ahead and send this into a breakout application to breakout number 3. Mr. Lewis, yours is coming. I can find you. Should never be difficult. Well, there you are. All right, we'll see you shortly, Mr. Wood. And we're on the record regarding case number 221946. This is Beaumont Health versus Laura Massengale. The matter is before the court set for a scheduling conference, status conference on today's date. Your appearance for the plaintiff in this matter, counsel.
Thank you, Your Honor. Hal Burke, P69068, attorney for Beaumont Health on this case.
All right, and do I have Miss Laura Massengale? If you're on the Zoom somewhere, please say something at this time. Miss Massengale? I see that there are, looks like there are a couple of people on the Zoom somewhere. Ms. Massengale, if you're there, please unmute yourself and say something. This is in regard to a person living on Rochelle Street in the city of Detroit. All right, the matter is set on for 9:45 p.m. It is, 11:30. It looks like Ms. Massengale is not checking and don't have any indication. Right, Council, given that that is the case, that Ms. Bassengale to have checked in today, I believe that you're moving for entry of default at this time. Well, just one moment. Before you respond to that, I see that I have a document saying I will be out of town, and this was always scheduled out from 1/18/22 to 1/25. I guess that was already scheduled. Attached airline confirmation. So Ms. Bassengale says that she could not be here because of the flight. This apparently just came up to the file, or I just saw it. It was filed on December the 19th. Mr. Burke, are you able to hear me okay?
Yes, I am. Sorry, Your Honor. I defer to you if you'd like to give Ms. Bassengale another opportunity to appear. She has not had contact with our office.
I'm going to go ahead and reset it, Council, given that I would have reset it if I had received this document. Someone just stuck it in the file, and so because she filed it on the 19th of December, I would have reset the date. So I'm going to go ahead and reset it now, and then we'll send a notice out to her of the new hearing date. So I'm going to set that date for the 8th. One second. Yeah, I'm going to set it for the 8th of February. 2/8. No, I can't set it that day. 2/7. I'm going to set it for 2/7, and that's going to be at 9:30 a.m.
Thank you, Your Honor. May I ask one other unrelated question? I did notice on the two notices I got for today for your court, it has your name, but the wrong Zoom code, and I logged into the other one. I'm not certain if anybody else is having that issue. That may be why some people aren't appearing, but just a note, it's always a pleasure to be in your courtroom.
Yeah, and that's a very important point that you raised, sir. What happened is my Zoom number was aligned with that. Well, they changed my courtroom. I asked for the change to 534. I thought that my Zoom number would be aligned with 534. So many of my notices went out with 534. In the future, you'll get the 336, even though my courtroom is 534. That's the problem. It wasn't with you or anybody. It's just that everybody was messed up because our notices were aligned with my courtroom, but they kept my Zoom the same though my courtroom changed.
Got it.
So
Totally understand. Thank you. Thank you.
the notice is going to come out with 336 in the future. Thank you, sir.
Sounds great. Have a great day. Thank you.
Judge, if I may real quick.
Yes, Mr. Callahan.
Yes, here on a Monique Carson matter, I'm just not sure if Ms. Carson has appeared at any time today. She's representing herself.
Which case is that? Which case is that, counsel?
It's Monique Carson versus the city of Detroit. Let me give you a case number here. I should put it in the. Let me give you the case number here, Judge. Is case number 2218038 GC.
That's Alicia Jones Coleman.
Oh, counsel, that's Alicia Jones Coleman, sir.
Okay.
That's the person that's in courtroom 336 now and has a Zoom 534. That's Alicia
Okay.
Jones.
All right. Yeah, that's tough because I had you, the last pretrial was in front of Your Honor.
What happened is that I would have been hearing that perhaps with the previous judge's case before she left Lydia Nance Adams. And so
Right.
now that they replaced her with someone, I think they put the file back over there. So That's what happened. So if you contact your courtroom, just let them know that you were here. If there are any problems, I'll verify.
Thank you, Judge. Thank you, Judge. Of course, it's, your last name's Coleman, and then the other judge is Coleman as well. So of course it would work out that way, huh? It's a good last name. So a lot of Judge Colemans.
We only have 4 judges on the civil docket. They reduced us by 1, and 2 of the judges on the civil docket are Coleman.
Yeah,
I'm
yeah.
related. You got 2 Colemans, and so it's 2 Colemans, Robinson, and who's the other person? Coleman, Robinson, and Henry Johnson.
Oh, okay. Yeah. They should put another, they should put a Cahalan or Callahan or a Hathaway or to even it out, right? And make it all names, right?
But those big names, you can go to the bigger courts.
Yeah, Hood. Yeah, Hood. They need a Hood on there. You can put me on there if you want, Judge. Thank you, Judge. I appreciate it.
Thank you, sir. Good day to you.
Yeah, you too.
All right, Mr. Rosen, we're back on the record regarding the Andrew Jones matter. That's the subject 7965.
Yes.
Ms. Francis, I do have that last case. I don't know how you got last. Well, I would never put you last, but somehow it happened, and I'm coming right to you, man. Just a moment. All right, Mr. Rosen, sir.
Yeah, just if I can build on the last year, I thought it was a job requirement to be judge in the 36th District Court to just be named Coleman. We can do a little court packing, have the whole civil division. But I'll wait for the next bench bar meeting and make that recommendation.
That's the way. That's the Hathaways. You got this mixed up.
Well, not back to serious nature of the law. I have talked to Mr. Jones in this case while the case was in recess in the breakout room. The parties have agreed to enter into a consent judgment. And the amount of the plaintiff's complaint, which was filed for $1,096.07. There were statutory costs of a $55 summons filing fee, a $55.38 summons service fee, total cost of $110.38. I indicated Mr. Jones that there is a statutory $75 attorney fee involved in these matters, and the total consent judgment would be $1,281.45. But the parties also agreed concurrently with the entry of this consent judgment that there will be a $50 monthly installment payment by Mr. Jones beginning January 22, 2023, and each 22nd day of the month thereafter. I gave Mr. Jones my phone number for him to call my office to make payment. I also received in the breakout room Mr. Jones' email address where I can email him a copy of the proposed consent judgment order for his review and signature. Once I've received back the fully signed and executed consent judgment, I will file that with the clerk's office, Judge, anytime between now and I imagine the end of next week.
Mr. Jones, that is your agreement regarding this matter, sir?
Yes, Your Honor.
All right, it sounds like a reasonable way to resolve the case. I will sign off on the document once it's submitted to court, and I'm noting the file as having been resolved. I wish you well, Mr. Jones. Thank you for being here.
Thank you, Judge. Plant rests.
Thank you, Your Honor.
Look forward to you getting that order. Okay, this is case number 22187073. This is credit acceptance versus Micah Ivy. The matter is before the court. Looks like on objection to a writ of garnishment was set on for 10 o'clock a.m. Wow, I didn't know we were that behind on these. If I'd known that there was an objection here, I probably would have got this a little closer. But anyway, all right, your appearance for credit acceptance, please.
Sorry, Judge, I actually have another credit acceptance matter
Is that one of ours for Weber and Olsey? Because I don't see that one. I have another one, 1815754 GC for an income tax garnishment.
All right, I don't have that one. Give me that case number again, we'll look it up.
1815754 GC.
Just one moment on that one. This one is with Weber and Olsey's. It
Yes.
relates to, last name is Ivy, Micah Ivy.
Sorry, Judge.
This is the state of Michigan, third party withholding.
That other one, she should have been adjusted.
And the other, okay, so this case involves a third party withholding. It also is there's a motion for installment payments. The other case that you gave us, that's Alicia Jones Coleman.
Judge Giles.
No, I'm sorry, that's Judge Giles.
Judge, the notice to appear that we received says Judge Donald Coleman, and it gives us your Zoom information. I can pull that up right now just to verify.
Yeah,
We believe you.
I believe.
But
you.
it's Judge Giles' case.
I believe you 100%, but it's Judge Giles' case, and so let's kind of get that worked out, figure out where you're supposed to be. Now, he's not there anymore.
Right, he's criminal.
They're not going up to criminal to February the 9th.
On to February 9th.
Yeah.
Okay, so Judge Giles is still there. What's Giles' Zoom?
360 537.
537, Madam Counsel. 360-537. And even though that's not your fault, you likely got a notice from me, but somehow they got it in the computer. It is properly assigned to Judge Giles. And if there are any problems with that, then you'll want to let them know, of course, that you were here in this court. I can verify that as well.
Okay. And then, sorry, Judge, as far as the other case that you have before you, can I get a case number for that so I can pull that file?
Sure, that's 22-187073. And do I have Micah Ivy on this roll? I'm looking for Ivy, last name Ivy. If you're on the Zoom. Say something at this time if you're on the Zoom. And while you're looking, Ms. Francis, I'm going to check with someone else and something else. Ms. Franklin, Crystal Franklin, I'm looking at. Why are you here? I can't hear you. You gotta hit.
Yes, I'm on.
Yeah. Good morning to you. Why are you here, Ms. Franklin?
Good morning.
Your case number.
My case number is 211-71988 GC.
211-71988, correct?
71988, yes.
One second. All right, so just hold tight, Ms. Franklin. I'll get some information. I'll be right back with you. All right.
Okay.
So, Madam Counsel, yeah, I don't see where Miss Ivy has appeared on this matter. There is an application for partial payments where she's asking to make partial payments at $75 every 2 weeks, so $150 a month. The judgment in that matter was $15,722.91, and the garnishment is against the third party withholding unit in this regard.
So Judge, sorry, then the hearing today is on a request for installment payments or on an objection?
It's on objection. It's on both. Objection to a writ of garnishment against the third party with Michigan Department of Treasury, and then also for partial payments regarding this matter.
Okay, so I don't see that we received her objection, so I'm not quite sure what the basis for her objection is, but I do see that the court did enter our order setting aside her installment payment plan. That was entered on January 3rd.
Right, and her objections, by the way, she indicated, I have an installment order issued on 9/23/22 regarding this case. And that installment order would not prevent what looks like an income tax garnishment.
Oh, there was an income tax garnishment issued, yes.
Yeah, so that would not stop the income tax garnishment. Regarding the partial payment request, I do see where the installment order was set aside. It indicated no payments had ever been received, and that's why the court set it aside. She was under a payment order. One second. That allowed $150 a month. Apparently, she never paid that. Now she's asking the court for an opportunity to pay under such an installment order.
Judge, if I may, as far as the installment payment order, given that the defendant just had an installment payment order where she failed to make any payments, and it was just recently set aside, and she also has failed to appear, I would request that her motion be denied. And as far as the objection to the income tax garnishment, given that there's no valid basis, I would ask that also be denied.
Yeah, I think that you're raising the right issues. I'm looking at a note that she sent. She said she was filling some request for garnishment. She indicated I granted her a monthly payments of $150 each. I was unable to make for December. I called the law office to inform them I would make payments in January. They never answered. Left messages. Voicemail states they called in 24 hours. I have been working with all my debt collectors. Personal integrity, I'm trying to do my best. Could you possibly lower the payment to $75? That would help me out. There would be major repercussions if a garnishment was to take place. I am your assistant specialist for 350 Social Security Administration. I would possibly use my government clearance. This would be detrimental to my career. Bankruptcy is not an option. Enrolled in college 3.0. Not just government system, child support. I have one son in preschool. Yeah, there is definitely some hardship issues, but she hasn't made any payments on the other order. I don't see a basis for granting the order. I don't see a basis for the objection, not at law. And so I'll deny I'll find the objections invalid, releasing funds withheld to the plan at this time. And motion for installment payments will be denied at this time.
Thank you, Judge.
I'm sorry for the wait, counsel.
Not a problem. Thank you, Judge. Have a good day.
Okay, did you find out what's going on this case number 21-71988?
It's
21-171-988.
Alicia Jones Coleman.
Oh yeah, you're in the wrong courtroom, Ms. Franklin. That should be in this Jones Coleman's courtroom. Judge Jones Coleman. So you will have to dial into her courtroom, ma'am. Are you still there, Miss? Did I lose her?
I think she did.
Looked like she left.
All right, Ms. Franklin, you're in the wrong courtroom, ma'am. So I want to give you the right courtroom that you have to go to. Are you able to hear me, Ms. Franklin? Franklin? Let's see if we can get you off. So if you hit
I
star,
don't think she's connecting. She's on mute herself.
yeah, you gotta hit *6 to be able to talk to me. Hit *6 on your device or hit the microphone. You said does not appear that she's connected.
Hello?
Okay, got it. All right. So Ms. Franklin, yeah, you're in the wrong courtroom, ma'am.
Hello?
Yeah, Ms. Franklin, can you hear me okay?
Yes, I can hear you.
Yeah, you're in the wrong courtroom. Your case is before Judge Alicia Jones Coleman. That's another Coleman, but that's not my courtroom. So you're gonna need to go to 360-534-0000.
Okay, you said 360
534
534
0000.
000. Okay.
I'll give you the phone number over there to that courtroom as well. That phone number is 965
965
2292.
2292.
Okay, so try to zoom in, and then if you're not able to reach Zoom, call the courtroom and let them know that you were in Judge Donald Coleman's courtroom. And that you want the opportunity for a hearing because you were in the wrong court, okay?
Okay.
I wish you
All right.
luck.
Thank you.
Okay, someone there with the 520 area code. Why are you here? I hear you.
I was here. My court record number is court case number 06149-201 DC.
Okay, I'm having a hard time hearing you. Let me stop you. I'm having a hard time hearing you. You said 06149, what else?
201 GC.
All right.
Can you hear me?
Yeah, so let's make sure we got the right number. You said 06149-201, is that correct?
Correct.
All right, let me check that one. You got it? Okay, just one moment, ma'am. I'll come right back to you.
You say what?
I'll come right back to you. I'll check again now. Hold on a second.
She's scheduled for January the 25th at 10 o'clock.
Your case is scheduled for January the 25th, 1:25. What time now?
10 a.m.
At 10 o'clock a.m.
Same Zoom.
Same Zoom number. You're gonna go in front of us, right?
Yes.
All right. Your Zoom, the Zoom number is 336. You come back into the same Zoom on the 25th of January at 10 o'clock a.m. You understand?
Okay, thank you.
All right, thank you. Good day to you, man.
Okay, you too.